I don't know about that. This is the legal argument that his lawyer just put in. Now, this right here, all this come from the same page, right? So on November 21st, 2008, defendants and his counsel, Wayne Wiggins, came to the United States Attorney's Office and reached a proffer agreement with AUSA Searwright. While detectives Caden and Dupree were present at the office, they were not privy to the discussions and never saw the final proffer. Harris, thank you, not Johnson. So Michael Harry O is Michael Harris. So he's not Johnson. So I don't know about that. Right. So a signed copy of the proffer agreement has never been located. However, after several efforts, Las Vegas Metro Police Department Detective Clifford Maughan was able to interview AUSA Timothy Searwright. First on July 20th, 2023, that's almost 2 years ago. And then again on January 8th, 2025. That's like 2 weeks ago. AUSA Searwright was unable to produce the actual proffer, but told Detective Maughan that he has used the same proffer letter, which has been the same or substantially similar for his entire career. AUSA Searwright provided Detective Maughan a copy of his standard proffer letter to criminal defendants. That proffer letter states in relevant part, you and your client understand that A, this agreement binds only you, your client, and this office. It does not bind any other law enforcement or prosecuting authority. B, law enforcement personnel will be present at the meeting as invited by this office. C, this agreement is limited to the statements made by your client at the meeting to be held on date and does not apply to any statements made by your client at any other time, whether oral, written, or recorded. And that right there is where Keefe D is screwed, right? Because say he did have a proffer agreement. That only was for that day. Nigga, any other time, any statements you made by your client at any other time, whether oral, written, or recorded, it does not apply. D, any information provided by you on behalf of your clients is covered by this agreement as it is made provided by your client. This agreement does not provide any protection to your client not expressly set forth herein. When asked if the defendant could have believed subsequent interviews were covered by this agreement, AUSA Searchlight indicated that while it was possible, he would have specifically told Davis and his attorney that proffer was only for a single conversation. Yeah, so Keefe D, he could go ahead with that proffer stuff. He's not covered. That was just for that one day, even if he did have it. So this synopsis is On December 18, 2008, the task force officers Gray Caden, William Holcomb, and Darren Dupree, along with Federal Bureau investigators, Special Agent Jeff Bennett, interviewed Duane Davis regarding the murder of Tupac Shakur. The interview was conducted at 8447 Wilshire Boulevard, Suite 100, Los Angeles, California. Also present was Davis attorney Wayne Wiggins. Details. At approximately 10:38 a.m., investigators met with Duane Davis at Davis attorney's office. Davis reviewed reports containing prior interviews Davis had completed. Davis pointed out several discrepancies in the prior reports, admitting he had not been entirely truthful about specific facts, including the circumstances surrounding the murder of Shakur. Davis was advised the purpose of the interview was to correct Davis' previous false statements as they related to the murder of Shakur and provided investigators with the factual details. Davis provided the following explanation. In the early 1990s, Davis associated with Flint. Flint is known to investigators as whatever Coleman. Coleman and Davis occasionally played against each other during neighborhood baseball games. Coleman was affiliated with the Santana. Member of the Santana Block Street Gang. Oh, okay. Yeah, like I said, I don't want to be reading all this stuff I'm telling on niggas. All right, I'm gonna go through this. So this is what we saw in the courtroom the other day with his Keefe D lawyer put in that motion, and this was his legal argument. Let's see. Confessions and admissions of the defendant may not be used to establish corpus delicti absenti sufficient independent evidence. Once the state presents independent evidence that the offense has been committed, admission and confession may then be used to corroborate the independent proof. However, all other relevant evidence may be considered. The corpus delicti may be established by purely direct evidence, partly direct and partly circumstantial evidence, or entirely circumstantial evidence. In the present matter, the state has no independent evidence that Orlando Anderson or any other member of the Southside Crips shot Tupac Shakur. This evidence comes solely from Mr. Davis' statements. The state has no evidence that a gun from Zip Martin was given to Mr. Davis and used in the shooting. The state has no evidence that the driver and the passenger white Cadillac were members of the Southside Crips. All of these are necessary to establish the corpus of the state indictment that Mr. Davis has orchestrated the shooting of Tupac Shakur without independent evidence corroborating Mr. Davis' statements. The indictment must be dismissed. Then the right of the due process. We seen there's all stuff he talked about in the court. Notwithstanding, no evidence was obtained immediately after the death of Tupac Shakur in 1996 by the Las Vegas Metropolitan Police. The following is a list of prejudices experienced by Mr. Davis to date: the death and inability of Orlando, Terrence Brown, DeAndre Smith, the incarceration of Suge Knight, the incarceration of Diddy, the death of Frank Alexander, the death of Zip, the death of Henry Lee Smith, member of a car entourage on the night of the shooting, inability to locate witnesses that might identify who was in the white Cadillac of the night of the shooting. Oh, they got Reggie for that. They using Reggie for that. The death and the unavailability of Los Angeles Police Department Detective Russell Poole. No matter what the state's justification, the 27-year-old delayed by failure to properly investigate the shooting of Tupac Shakur and failure to prosecute Mr. Davis after his 2009 statement has unfairly, irreparably harmed Mr. Davis from having a fair trial from his constitutional due rights. All this was denied. They denied it. All this. This was a waste. I ain't gonna say it was a waste. This man got to do his job, but